Hey folks, this is Dennis Boren. I'm a criminal defense attorney and former felony prosecutor. And as I've said on all the other videos, when I was a prosecutor, I was trained by this gentleman, Mr. James Farron, who thankfully took me under his wing, and I'm one of his biggest fans. He's, after we left the DA's office in Amarillo, he was elected to as a Randall County Criminal District Attorney and served for what, James, 22 years?
24 years.
24 years and retired about a year and a half ago. And I thought today would be a good time to kind of go through a few things with him, and I hope to do a series of interviews with James. Today I wanted to ask him to kind of tell us about, from a prosecutorial point of view, what the role of defense attorneys are and kind of the role of the relationship between the two. So James?
Okay. Well, it is an adversarial relationship only in the professional sense of the word. The defense attorney's role in a very summary sort of explanation is to provide the very best defense he or she can for their client within the limits of the law, while the prosecutor's role is to, first of all, seek justice, not just convictions.
And that's actually in your oath, isn't it, as a prosecutor, when you get sworn in?
Absolutely, it is. It's an oath. Prosecutors are the only attorneys in the criminal justice system, or elsewhere for that matter, that take an oath to seek justice. That doesn't mean that the defense attorney is not also seeking justice. What is sometimes confusing to the layman is that justice and truth are not always the same thing. In the criminal justice system, justice primarily concerns the person accused. Did they receive all of the protections of the law that our system provides? Was due process provided? Was there a fair trial? Did they have an opportunity to consult with their attorney and present evidence and enjoy discovery? Things of that nature. While the prosecutor's role is to also seek justice, so is the defense attorney, because if those kinds of steps take place, if regardless of the result, if the person accused was provided a fair process, a fair opportunity to challenge the accusations made by the state against them, then that's justice regardless of the outcome. Where the layman would think of justice as, well, did this person really do it or not, and were they convicted? And in a perfect world, that would be true, but the criminal justice system is limited because it's a human created system. And in that system, the first concern is to protect the rights of the accused. We as humans often rightfully and morally are concerned about the rights of the victim, and the system provides for that as well. But the first goal is to make sure that when all the power of the state is brought against one individual or group of individuals accusing him or her of them of committing a criminal act, that we make sure the state plays fair. And
in that regard, would you kind of tell us about, you mentioned the discovery and turning over exculpatory evidence or evidence that would tend to prove or go toward the innocence of the defendant, and in the Michael Mortensen Act, just
sure. If the defense has information in their possession that would be helpful to me in seeking a conviction, they have no legal obligation to provide that information to me. I have very limited access to what's in their file and what information they have. On the other side of the aisle, the defense has a tremendous ability to see my file and to learn everything that's in my file. And in Texas, after the Michael Morton Act, that's even more true. Almost every state has to abide by the rules of Brady. If I'm aware of exculpatory evidence that might help the defendant either show that he or she didn't commit the act or that the punishment should be lessened. Under the Brady ruling, I have an obligation to provide that to them. But Texas goes beyond that. We have the Michael Morton Act, and basically I'm required to provide my entire file to the defense. Everything that I have in that file, I have to make sure that they receive it and actually have that information. And if new information comes to light, then I have an obligation to provide that to them, even though it may hurt my case and it may make it more difficult for me to prove my case.
Yeah,
And that's
yes, you have to certify that to the court. You have to enter a pleading telling the judge that you have in fact done that, and the defense attorney has to sign off saying, as far as we know, that was complied with. So it's
correct. The court has to be satisfied that the prosecution has complied with that requirement before the trial begins. If the court is not convinced of that, under law, the court cannot allow the trial to proceed. Whether it's a plea or a full-blown trial, the court is not, under the law, supposed to allow that to occur unless the judge is satisfied that the Brady requirements of providing all the information that the state has in the file that's going to be used against the defendant, that all of that is provided to the defendant so that the defendant can prepare the defense that they're going to utilize.
Well, James, thanks a lot. And we've got to wrap it up for the
Sure.
note, just to keep this within some reasonable length. And folks, we're going to have more interviews with James. There's just a lot of subjects we can talk about, and we're going to do that. So look forward to those in the future. Again, as I tell you many times, if you're encountering the police, the best practice is turn on your cell phone, smartphone video app, or at least your audio app, and record what's going on. That will protect you. I hope this was helpful.
Thank you, Dennis.